The right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013. Chapter 4. Section 21. Notice to persons interested. 1. The collector shall publish the public notice on his website and cause public notice to be given at convenient places on or near the land to be taken, stating that the government intends to take possession of the land, and that claims to compensations and rehabilitation and resettlement for all interests in such land may be made to him. 2. The public notice referred to in subsection 1 shall state the particulars of the land so needed, and require all persons interested in the land to appear personally or by agent or advocate before the collector at a time and place mentioned in the public notice, not being less than 30 days. And not more than 6 months after the date of publication of the notice, and to state the nature of their respective interests in the land and the amount and particulars of their claims to compensation for such interests, their claims to rehabilitation and resettlement along with their objections, if any, to the measurements made under Section 20. 3. The collector may in any case require such statement referred to in subsection 2 to be made in writing and signed by the party or his agent. 4. The collector shall also serve notice to the same effect on the occupier, if any, of such land and on all such persons known or believed to be interested therein. Be entitled to act for persons so interested, as reside or have agents authorized to receive service on their behalf, within the revenue district in which the land is situated. 5. In case any person so interested resides elsewhere, and has no such agent, the collector shall ensure that the notice shall be sent to him by post in letter addressed to him at his last known residence, address of place or business, and also publish the same in at least 2 national daily newspapers and also on his website. Section 22. Power to require and enforce the making of statements as to names and interests. 1. The collector may also require any such person to make or deliver to him, at a time and place mentioned, such time not being less than 30 days after the date of the requisition, a statement containing, so far as may be practicable, the name of every other person possessing any interest in the land or any part thereof as co-proprietor, sub-proprietor, mortgagee, tenant or otherwise, and of the nature of such interest, and of the rents and profits, if any, received or receivable on account thereof for 3 years next preceding the date of the statement. 2. Every person required to make or deliver a statement under this section shall be deemed to be legally bound to do so within the meaning of sections 175 and 176 of the Indian Penal Code, 45 of 1860. Section 23. Inquiry in Land Acquisition Award by Collector. On the day so fixed, or on any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections if any which any person interested has stated pursuant to a notice given under Section 21, to the measurements made under Section 20, and into the value of the land at the date of the publication of the notification, and into the respective interests of the persons claiming the compensation and rehabilitation and resettlement, shall make an award under his hand of a. The true area of the land. B. The compensation is determined under Section 27 along with rehabilitation and resettlement award as determined under Section 31 and which in his opinion should be allowed for the land, and C. The apportionment of the said compensation among all the persons known or believed to be interested in the land, or whom, or of whose claims, he has information, whether or not they have respectively appeared before him. Section 24. Land Acquisition Process under Act No. 1 of 1894 shall be deemed to have lapsed in certain cases. 1. Notwithstanding anything contained in this Act, in any case of land acquisition proceedings initiated under the Land Acquisition Act, 1894, a. Where no award under Section 11 of the said Land Acquisition Act has been made, then, all provisions of this Act relating to the determination of compensation shall apply, or b. Where an award under said Section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act, as if the said Act has not been repealed. Comma. Where an award under the said Section 11 has been made 5 years or more prior to the commencement of this Act but the physical possession of the land has not been taken or the compensation has not When paid, the said proceedings shall be deemed to have lapsed and the appropriate government, if it so chooses, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of this Act. Provided that where an award has been made in compensation in respect of a majority of land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under Section 4 of the said Land Acquisition Act, shall be entitled to compensation in accordance with the provisions of this Act. Section 25. Period within which an award shall be made. The collector shall make an award within a period of 12 months from the date of publication of the declaration under Section 19, and if no award is made within that period, the entire proceedings for the acquisition of the land shall lapse. Provided that the appropriate government shall have the power to extend the period of 12 months if in its opinion, circumstances exist justifying the same. Provided further that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded on the website of the authority concerned. Section 26. Determination of market value of land by collector. 1. The collector shall adopt the following criteria in assessing and determining the market value of the land, namely: A. The market value, if any, specified in the Indian Stamp Act, 1899 for the registration of sale deeds or agreements to sell, as the case may be, in the area where the land is situated. Or B. The average sale price for similar type of land situated in the nearest village or nearest vicinity area, or C. Consented amount of compensation is agreed upon under subsection 2 of Section 2 in case of acquisition of lands for private companies or for public-private partnership projects, whichever is higher. Provided that the date for determination of market value shall be the date on which the notification has been issued under Section 11. Explanation 1. The average sale price referred to in Clause B shall be determined taking into account the sale deeds or the agreements to sell registered for similar type of area in the near village or near vicinity area during immediately preceding 3 years of the year in which such acquisition of land is proposed to be made. Explanation 2. For determining the average sale price referred to in Explanation 1. 1/2 of the total number of sale deeds or the agreements to sell in which the highest sale price has been mentioned shall be taken into account. Explanation 3. While determining the market value under this section and the average sale price referred to in Explanation 1 or Explanation 2, any price paid as compensation for land acquired under the provisions of this Act on an earlier occasion in the district shall not be taken into consideration. Explanation 4. While determining the market value under this section and the average sale price referred to in Explanation 1 or Explanation 2, any price paid which in the opinion of the collector is not indicative of actual prevailing market value may be discounted for the purposes of calculating market value. 2. The market value calculated as per subsection 1 shall be multiplied by a factor to be specified in the first schedule. 3. Where the market value under subsection 1 or subsection 2 cannot be determined for the reason that A. The land is situated in such area where the transactions in land are restricted by or under any other law for the time being in force in that area, or B. The registered sale deeds or agreements to sell as mentioned in clause A of subsection 1 for similar land are not available for the immediately preceding 3 years, or by the appropriate authority. The state government concerned shall specify the floor price or minimum price per unit area of the said land based on the price calculated in the manner specified in subsection 1 in respect of similar types of land situated in the immediate adjoining areas. Provided that in a case where the requiring body offers its shares to the owners of the lands whose lands have been acquired as a part compensation for acquisition of land, such shares in no case shall exceed 25% of the value so calculated under subsection 1 or subsection 2 or subsection 3 as the case may be. Provided further that the requiring body shall in no case compel any owner of the land whose land has been acquired to take its shares, the value of which is deductible in the value of the land calculated under subsection 1. Provided also that the collector shall, before initiation of any land acquisition proceedings in any area, take all necessary steps to revise and update the market value of the land on the basis of the prevalent market rate in that area. Provided also that the appropriate government shall ensure that the market value determined for acquisition of any land or property of an educational institution established and administered by a religious or linguistic minority shall be such as would not restrict or abrogate the right to establish and administer educational institutions of their choice. Section 27. Determination of amount of compensation. The collector, having determined the market value of the land to be acquired, shall calculate the total amount of compensation to be paid to the landowner whose land has been acquired by including all assets attached to the land. Section 28. Parameters to be considered by collector in determination of award. In determining the amount of compensation to be awarded for land acquired under this Act, the collector shall take into consideration: firstly, the market value as determined under Section 26 and the award amount in accordance with the first and second schedules. Secondly, the damage sustained by the person interested, by reason of the taking of any standing crops and trees which may be on the land at the time of the collector's taking possession thereof. Thirdly, the damage, if any, sustained by the person interested, at the time of the collector's taking possession of the land, by reason of severing such land from his other land. Fourthly, the damage, if any, sustained by the person interested, at the time of the collector's taking possession of the land, by reason of the acquisition injuriously affecting his other property, movable or immovable, in any other manner, or his earnings. Fifthly, in consequence of the acquisition of the land by the collector, the person interested is compelled to change his residence or place of business. The reasonable expenses, if any, incidental to such change. Sixthly, the damage, if any, bona fide, resulting from diminution of the profits of the land between the time of the publication of the declaration under Section 19 and the time of the collector's taking possession of the land, and seventhly, any other ground which may be in the interest of equity, justice and beneficial to the affected families. Section 29. Determination of value of things attached to land or building. 1. The collector, in determining the market value of the building and other immovable property or assets attached to the land or building which are to be acquired, use the services of a competent engineer or any other specialist in the relevant field, as may be considered necessary by him. 2. The collector, for the purpose of determining the value of trees and plants attached to the land acquired, use the services of experienced persons in the field of agriculture, forestry, horticulture, sericulture, or any other field, as may be considered necessary by him. 3. The collector, for the purpose of assessing the value of the standing crops damaged during the process of land acquisition, may use the services of experienced persons in the field of agriculture as may be considered necessary by him. Section 30. Award of Solitium. 1. The collector, having determined the total compensation to be paid, shall, to arrive at the final award, impose a solitium amount equivalent to 100% of the compensation amount. Explanation. For the removal of doubts, it is hereby declared that solitium amount shall be in addition to the compensation payable to any person whose land has been acquired. 2. The collector shall issue individual awards detailing the particulars of compensation payable and the details of payment of the compensation as specified in the first schedule. 3. In addition to the market value of the land provided under Section 26, the collector shall, in every case, award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of the notification of the Social Impact Assessment Study under subsection 2 of Section 4. In respect of such land, till the date of the award of the collector or the date of taking possession of the land, whichever is earlier.